Hello, my name is James Brinkley. I'm the co-founder of IPGen, where we're building tools to streamline and automate the IP processes. We're here in conjunction with TEDCO to give you a bit of information about business formation and IP as a whole.
Good afternoon, everyone. My name is Starlyn Priest, and I am an attorney and co-founder of IPGen. And today we're going to cover business entity formation in a workshop session in partnership with TEDCO. Just a little bit about some pre-launch activities that you want to consider before launching your company. First and foremost, you want to make sure that when you're thinking about starting a company, you're actually identifying the problem that you have a solution to. A lot of times companies are started without a lot of thought being put into the very important beginnings of that process. And so you want to make sure that you have a very clear business proposition and you know what problem your business is solving. Another pre-launch activity or some thinking that you want to do in the beginning is to make sure that you're conducting a very thorough market analysis of what your company, the space that your company is actually competing in. So you want to understand your customers. You definitely want to make sure that you have some clarity and do some research around customer data to really make sure that you're launching a company that has great potential for success. Another thing that you want to consider would be to identify internal talent gaps. So do you have talent that you're missing on your team that you want to make sure that you gather? Is there data insights that you need? Is there a salesperson? Maybe you have a great idea, but you don't have sales talent. So there's a lot of things that you want to consider actually before starting your company, and that would be one of them. Another great consideration is to understand if you have subject matter experts that you need to consult with to really understand your industry and get some insight as to maybe your particular product. Maybe there's some science that you need to understand when you're making a new product. You want to make sure that you're developing and refining your product or service. So again, putting a lot of thinking into that. Maybe it's if you're a tech company, or maybe a product company that can develop their products relatively easily, maybe you want to develop a minimally viable product, so what they call an MVP. So these are some of the things that you want to think about even long before you establish that business entity. You definitely want to look into if there's any type of early adopters. So a lot of times in tech companies, they'll identify those individuals that love to try new tech. So in those situations, maybe it's finding some of those beta users that will help to give feedback on what that technology or that product does. So those are some of the things that you want to test out, again, before you're even forming your company. You also want to think about if there are, some resources that you need to consult. And then last but not least, and definitely not least in the context of what we are here to talk about, you want to make sure that before you're forming your company, you've done a little bit of research and consulted with an attorney to understand if your company name or company product could potentially infringe on someone's intellectual property rights. So you want to do a lot of those things in advance because sometimes you have companies that start and they put all this work and energy into building the company, and then they realize, oh my gosh, somebody else has this company name, or maybe somebody else has a product that shares the same name. And so don't want to get into trouble with infringing on people's intellectual property rights and other companies. You don't want that trouble. So these are some of the things that you want to take in consideration in advance of forming your business entity. So after you've done that work, another big consideration when you're looking to launch a company is having some clarity around what type of funding you might want to raise. So not every company is going to raise the same types of funding. Some companies are more suitable for what you hear out there, venture capital funding or angel investing. Some companies are more appropriately positioned for that type of business, but you have others that would benefit from, say, lending. So there's tons of lending options out there, whether you're going to a traditional financial institution or you are maybe seeking some funding from the government. There's a lot of different loan products out there from the federal, state, and local levels. So there's lots of options there. You want to think about funding because that directly ties to how your company is formed. So let's say, for example, you have more what is called a lifestyle business. If your business is not a high growth, scalable kind of company, and you want to work with your experts or your attorneys to really understand what that could look like and what that actually means, you want to consider how that could impact your ability to attract investment dollars. So if you're looking to eventually raise venture capital funds, let's say you're a technology company and many of them do this, if you're looking to raise some venture capital funding, then forming or having a company that's, say, a sole proprietor is not going to be the desired entity from their perspective. And there's some reasons why, and we'll talk about that a little bit later. So additional factors, again, just mentioning some of the things before you actually launch. Again, will you have investors? Will you need consultants and other technical labor that are going to be hired as independent contractors? The reason why you want to consider those factors is because maybe you might have some independent contractors that you can't pay upfront, and sometimes you can utilize equity as ways to compensate for the types of skills that you need, but you're not able to, say, pay, in a traditional sense in that very early stage of your startup. In situations like those, definitely having a company or a business that's operating as a sole proprietorship is not going to be sufficient to provide that type of ownership shares within the company. And so this is why it's important to think about these things before you form a company. Relationship with legal counsel. Of course, I might be biased. As an attorney, I'm always encouraging companies to make sure that you have attorneys before you actually need attorneys. So getting the attorney before you're in trouble, before there are problems, and building that relationship is incredibly helpful to you making the right decisions fresh out the gate, and so that you are taking the right steps. So that's something else that you want to consider before forming an entity. Getting a tax professional, having an accountant, all of these relationships are really, really important to understanding why you make certain business entity selections. So having the consult of those individuals is very, very valuable to you having a great launch of your business. So as I mentioned before, you definitely want to make sure, I can't stress this enough, that you're not naming your company or your products something that is owned by someone else, a federally protected or even a state protected right in some regards. So you definitely want to work with your attorney to make sure that you have done that work in that due diligence there. So whether that's checking your state, Secretary of State's websites to see if there's any type of brand name or trade name protections for the state, you want to make sure that you do that. Now, even if it's protected on a state level, that does not give you federal protection. So it's very important to understand that while there might be a trade name registered for a state, that does not mean that it's necessarily a federally protected mark. So one of our other presenters will go into the great details around that later, but very important to understand before you're launching your business entity. Some other important checklists before you get to corporate formation. You want to make sure that you have your IRS or EIN. So right after you launch, you want to make sure that you have your EIN number, your employer identification number. You're, of course, registered with whatever state you're located in. I'm a licensed attorney for the state of Ohio, but whatever state you're located in, you definitely want to make sure that you have complied with all of the rules and regulations for that state as it relates to registering a business. So as I mentioned before, there are different types of companies that you could start. You could have a sole proprietor. We'll talk a little bit about that. You can have what you often hear a lot about now, limited liability corporations. There's corporations, there's S corporations, and then there's also partnerships, which there can be a whole, numerous of different types of partnerships, and we'll talk about that. Why different corporate entity formation is important is because it may dictate how much liability you face as a company owner or as a vested partner in a company. It can impact your taxes. So how your taxes are filed, that is another thing that is contingent upon business formation. And then also, as I mentioned before, investment fundraising. So these are just three of the factors that are affected when you're talking about business entity formation and just which entity you select. So now I'm going to speak a little bit about some of the pros and cons of each type of business entity formation. So I'll start off talking about sole proprietorship since that's the most simple. Sole proprietorship is really someone who owns an unincorporated business by himself or herself. So essentially you say, hey, I want to make candles. If you decide you want to be a candle maker, you're making candles and you're selling them. That's a sole proprietor. When you are a sole proprietor, there are some advantages and disadvantages, and I'll go through those. Some advantages of being a sole proprietor is very easy. You can just get started. There's really no barriers to entry there. Oftentimes people start their side hustles, so to speak, in that way. So they just get started. So it's simple, it's affordable, there's no barriers to entry there. You have full and total operating freedom. So there's really no formalities when it comes to how you operate your business, and there are no filing requirements. What I mean by filing requirements is that the state that you live in may not necessarily have you report certain things as they would if you are an actual formed entity. Now, the disadvantages to being a sole proprietor, while it's easy, you don't have to, no one's really checking in to see if you're doing record keeping. The disadvantages is that there's really unlimited liability to you as a person. So you essentially are the business. That means if anything happens as it relates to your products or services, you can be held liable in that situation because there's no legal separation between you and your business operations. There also can be challenges when you're talking about raising investment funding. As I mentioned earlier, when you are, say, a tech company and you're looking to raise some investment dollars from a venture capitalist or even an angel investor or fund of any type, most times they are not going to just provide a person themselves the funds, to invest in that business. That looks very different. If you're a sole proprietor, you probably want to do the friends and family. You can go for the friends and family type of fundraise. But when you're looking to develop and scale a company that, say, is like a technology company, for example, they're going to be looking for a separation between the founders and the folks that are running the company and the actual business itself. So that's a challenge when raising investment funding. If you're a sole proprietor, you're probably not going to get dollars. And then the other challenge or disadvantage to having a sole proprietorship is you often, many times what I've found in consulting with lots of different companies is that there's difficulty in maintaining separation and financial control. It's hard to keep track of records. A lot of times people don't have separate logs and receipts and records for what's solely their business operations versus what's their personal expenditures and just day-to-day life. And so not having that separation makes it very, very challenging to do another number of things. You often can't show records of your business operations in a very clean and easy to digest format. This is why, and it kind of leads to a mess when it comes to records. And as a result of that, it would definitely be hard to, say, get a loan from someone or to raise investment funding. So those are the disadvantages of the sole proprietorship. On to the next entity, which everyone is talking about, limited liability companies. You hear so much, get your LLC. You hear it everywhere, you see it everywhere. A limited liability corporation is a business structure that is allowed by state statute. Now, what that actually means is that your state dictates what are the rules that governs that legal entity. So that means that you have to work, again, with your attorney to really understand what requirements are for your state. But with the limited liability corporation, there is a separate business entity from yourself. So that's just a next level up. It's not the maximum separation, but there is some protection that a business owner has that is separate from the business operation. But of course, with all good things, there are going to be requirements associated with it. So just to give you some insight, when you are looking to establish a limited liability corporation, there could be naming requirements with the state. So you have your articles of organization, which is normally filed with the Secretary of State for whatever state you're located in or your company is located in. And there are going to be rules. They may say, hey, you need to have the words limited liability company at the end of your company name, or LLC or limited, or some type of acronym that indicates to the public, to the market, that you are a separate entity. That's extremely important for the market to understand that you are a business and you are not the business, so to speak. Articles of organization will often have information on there like how long have you been in business, your effective date. In the state of Ohio, it's pretty much 90 days. The maximum is like 90 days from the date that you filed, no later than 90 days from the date that you filed. Period of existence, your purpose. Definitely want to work with your company, or I'm sorry, with your attorney. Want to work with your attorney to get clarity on whether or not it makes sense for you to indicate a purpose in your articles of organization. There are some legal implications to why some companies choose not to list a purpose on that document, some of which has to do with as you grow, could the corporation itself or partners within the corporation say, hey, if you're looking to go into a business, maybe it's an industry that is not defined within the heart of what that company was formed for, there could be challenges there. So there's some theories out there about whether or not you want to list an actual purpose, or it could be vague, like just your company exists solely to do legal business. So you want to work with your attorney to get clarity on that. Then also on the articles of organization, there's going to be a requirement for an appointment of statutory agent. What that means is that is the person that would be served in the event that there was a lawsuit. So there needs to be a name, there needs to be some indication of who is responsible to receive some type of service in the event that your company is sued. So just to talk a little bit about some of the advantages and disadvantages of a limited liability corporation. Advantages, there's separation between yourself and the business. It's easier to raise investment funding. Now, again, I still encourage, for those that are looking to raise venture capital funding, you'll often find that at some point, even if a company starts off as a limited liability corporation, they may later change to an actual C corporation. We'll talk a little bit about why that is later. There's pretty loose formalities. You have, at least for the state of Ohio, directors or appointed directors are optional. So you have some titles that are required depending on state law for a limited liability company. The other advantage is that there's a flow through tax treatment. What that actually means is that it's an attractive benefit for investors who want to use like a startup company's losses as a way to offset their profits. Now, when you're looking to file taxes, and when it's tax season, typically because a limited liability company is not recognized by the IRS as an actual legal entity, there are some things that you want to work with your tax professional and your attorney to understand as far as how the operations and the financial activities of your company will impact you personally, even though there is separation there. Some disadvantages to the limited liability corporation is that it's not as great of a separation as with the C corporation. That's why it's limited. So your liability for the company, while it is still challenging for, say, someone to sue the company and be able to come after you as the owner of the company, it's still not the maximum protection that is out there. However, we'll talk a little bit about why C corporation may not be the appropriate option for some individuals who may not be at that stage in their business per se. So another disadvantage is that members must assume responsibility for their share of the limited liabilities income. So there's definitely, when you are a member manager of the limited liability corporation, you are responsible for that share of the actual company. So you might have 3 partners, all 3 of you have your responsibility as it relates to the income. And yeah, so those are some of the things that you want to consider when you're thinking about a limited liability corporation. You also want to make sure that you're working with your attorney to also have your operating agreements in place. So when you have a limited liability corporation, you need to have an operating agreement, some rules that govern how that company is being ran. A lot of people miss that step, so that's certainly important. Okay, so now we can talk about the C corporation. A C corporation, or a C corp, as you may hear it, is a legal structure for a corporation in which owners or shareholders are taxed separately from the entity itself. So a C corporation is an actual being in and of itself. So to form a C corporation, and again, please work with your attorney to understand if your business has reached that stage or if it's appropriate. The C corporation is appropriate for the type of business that you have. But the purpose, some of the documents that you need with a C corporation is what's called an Articles of Incorporation. So when your attorney files with the state, the Secretary of State for whichever state you're located in, you will get what's called an Articles of Incorporation. That document is filed with the Secretary of State, and it essentially is what I call the constitution of your company. Very, very important document. There are lots of rules around what has to happen in order to make changes to that founding document. Lots of additional steps involved in that versus the limited liability corporation, as I mentioned before. But to form a corporation, a lot of times you need some type of indication that it is in a corporation. So whether it's the word corporation, or you might see an acronym that says co, or the word company itself. On that Articles of Incorporation, it will have principal place of business. So where does the company actually operate? It will also have what's called a number. You have to indicate the number of authorized shares. And then you'll also see par value. So when you're talking about authorized shares, these are the shares of the company. If you think about the company like 100% of the pie, right? You have slices of the pie, and that pie is divvied up into shares, and you have to indicate how many slices are in that pie that make up your corporation's ownership. So it's ownership pie. That's an easy way to remember that. You need to indicate on the Articles of Incorporation your initial stated capital. So how much money did it take to start that? What is the beginning funds that were put into the company to start that company? Just like with the LLC, you also need a designated agent for service of process. So again, this is in the event that your company is sued. And again, this is separate from yourself. If your company is sued, then you need to indicate who is the person that would accept service for any type of filing that's placed against you. Now, as I kind of mentioned before, and I'll mention it again, there is some indication most times in a corporation's document on the Articles of Incorporation, it'll have a corporate purpose. Again, you want to make sure that you're working with your attorney to understand whether or not it's appropriate to narrowly define what your business is in that regard. So sometimes you can indicate, as I mentioned before, legal business activities. You'll see that with large corporations. That allows them the flexibility to be able to go into a lot of different spaces. With a corporation, I will just stress that is particularly important because you have shareholders. And when you have shareholders, there are various things actions that shareholders can take. When they have shares in a company that they can take against board members, senior leaders, there's the company itself. And so you definitely want to make sure that there's clarity and you work with your attorney to know why that would or would not be appropriate for you to complete the corporate purpose. So in addition to your Articles of Incorporation, there's also a document called your bylaws. So just wanted to share really quick what the purpose of the bylaws are. Your bylaws are a series of rules, policies, and processes that governs how the corporation will operate. So for a limited liability company, your operating agreement. Your operating agreement would kind of give some indications of the similar kinds of things, but with a C corporation, these are very, very important. It's how you set forth your rules around voting and how decisions will be made and who can do what. So it's a very, very important document to have. Within the bylaws, you'll also lay out, how much power and influence the votes have, or, each vote. Conflicts of interest provisions, your officer duties. You'll also have the process for if you want to change the bylaws. So that has to be in there as well. So very important information. Again, with the C corporation, there are more requirements. And so you have to follow these to stay compliant with your state rules and regulations. So some advantages of a C corporation. When you have a C corporation, obviously there's maximum liability protection. So if you are, shareholder or officer, or shareholder and officer of a corporation, if someone wants to sue the company because maybe their service is bad, or maybe something happened with a product that you produce, they can't sue you directly. In states where, let me take that back, it is very challenging to do. Okay, I won't ever say ever. However, there is maximum protection when you have a C corporation because it is treated as a separate entity, meaning any of the activities that stem from the company, the first line of defense, so to speak, if someone wants to sue or they want to say you're liable for some injury of some sort, they have to go through the company. In order for a court to say, you know what, we're going to actually allow, and this is, I'm explaining this without using all the legal terms, but in order for, a court to allow a person to sue you directly, when you have a C corporation, there's a lot of things they have to show in order to reach you as an individual. So some of the things that are important to consider around this, or when companies or when courts will say, hey, you know what, while there is a C corporation, the owners weren't acting like they were a C corporation. There's situations where that will happen. Some of the examples are when a corporate entity is what's called undercapitalized, so there's barely any capital in the company, and essentially the owners, the shareholders, they're treating the company as though they're them. There's no separation. It's just them. When there's commingling between personal funds and the corporation's funds, that's another situation. So if you're financially acting as though that corporation does not exist as a separate entity, that can be grounds for a court in certain situations. They say we're questioning whether or not we should treat this corporation as a separate entity because the owners weren't treating it that way. If books aren't kept separately, again, financial piece, or if there are different actions that are not authorized by the board of directors or shareholders. In situations like those, again, because there are lots of requirements, if you're going to have a C corporation, you have to truly treat it separately. Another, just a quick mention, I mentioned it earlier, venture investors, they prefer C corporations because of the separation, and it's also a benefit. There's a benefit of having different classes of stock. And so again, work with your attorney to understand what that means. It carries different weight depending on the classes of stock you have. And then IPOs, when you hear about companies going public, those are C corporations most times. So that's something else you want to consider if your company has a high growth potential for going public at some point. But disadvantages of C corporations, there's operational formalities. If that hasn't been clear at this point, you have to make sure that you're having your annual meetings. So there's meeting requirements. There's all of these requirements that your state may have for you. Oftentimes you'll see large corporations are located in places like Delaware. The reason why is Delaware is a very corporation-friendly state. Lots of companies that might be operating in other states across the country or the world, they have C corporations that are based in Delaware. And the reason is because of their friendly laws there. The second disadvantage I'll note about the C corporations is a double taxation issue. There's definitely 2 layers of taxation involved in understanding the nuances of that. Definitely work with your tax professionals to understand that as well. And then there's 2 last things. S corporations are most times what I've found with companies that I've worked with, most times they don't need an S corporation. But essentially, shareholders of an S corporation, they can report disadvantage. They can report flow through income and losses on their personal tax returns. Typically, it's a very small group of individuals that have an S corporation. Most times it's not the appropriate entity for many businesses. And I tend to find that more sophisticated business people that maybe have like small investment groups, they may tend to form those types of entities. But with S corporations, the disadvantage is that you are responsible for certain tax on built-in gains and passive incomes at the entity level. So there's a difference. Again, there's tax implications there with that type of entity. The last category are partnerships, and there's kind of a number of different partnerships. It's also based on your state guidelines as well, but I'll just give you a quick preview on some different types. There's general partnerships, limited partnerships, and then limited liability partnerships. With a general partnership, it's very easy to form, and you don't actually need anything in writing to form it. So I always encourage business folks or entrepreneurs to just be very careful when we're talking about, you're saying, oh, that's my partner. When you use that language, it does carry meaning to it. And so with a general partnership, it's an association of two or more people that agree to do business for profit. In that situation, each person contributes their money. It might be their property, their labor, their skills, and then they share profits and losses for the business. The advantages of a general partnership is that there really aren't most times any filing requirements. You may want to file what's called a statement of partnership authority, which kind of outlines, here's what this partner is authorized to do versus here's what this other partner is authorized to do. This helps in the event that, just like marriages, partnerships can break up. And when that happens, we need clarity on who's responsible for what, who is authorized to do what. And so that statement of partnership authority does help to bring that clarity in the event that you end up in litigation. A partnership can be formed, again, just upon agreement. You don't need any writings. And essentially, it's governed by the partnership agreement. So those are the rules of that engagement. The disadvantages is that everyone has personal liability. So if we lose $100,000, everybody loses $100,000, all shared, it's all the same. So that is something that is a disadvantage. A limited partnership, though, a limited partnership is still an association of two or more persons deciding to do business together for profit. But typically there is a general partner and then there is someone that's a limited partner. You may see a lot of investment companies like venture companies or small funds structured in this way. Limited partnerships can also be formed not just between individuals, but entities as well. So there are definitely state rules around that. But in that situation, a general partner has managerial control. They have the power to bind a partnership. They act as an agent for the company. So they have the ability to bind that company or that business operation to business agreements, enter into contracts. They also act as, they also have the greatest liability when it comes to, if the company itself or the business itself loses money, they actually have liability for that, whereas that's not the same situation for a limited liability partner. But some of the advantages, liability is segmented. So again, general partner has liability, limited partner has really limited liability. So they don't have to worry as much. General partners definitely have more responsibility. But the flip side to that is if you're a limited partner in that relationship, you don't have the same managerial control. Disadvantages, the general partners in those entities are jointly and severally liable for partnership debts. What does that mean in English? What that means is that the losses for the partnership are your losses as a general partner. Limited partners have no managerial control over partnerships. And so that's another disadvantage because maybe your general partner is doing something that you don't agree with. If you're a limited partner, then in that situation, you don't necessarily have the control to make certain changes that you would want to see. So that gives you an overview of all the different types of entities. And it's definitely, again, I encourage everyone to consult with their professionals, their team, getting your team in line in the beginning consult with your team to make sure you're making those good decisions right from the beginning. Thank you so much.
Thank you, Starlyn. I just, every time I hear you speak on business entities and formations, I learn something new every time. Even though I'm an attorney myself, I still learn new things every time I hear you speak on that topic. You gave such great tidbits for people to take and digest as they begin to form their partnerships. But we're going to move forward now to speaking about IP, intellectual property generally, and specific details on each one. So we have Ego speaking on that, and she'll introduce herself next.
Hello, my name is Ego. I'm an attorney and I'm licensed to practice in DC, and I'm an IP attorney at IPGen. And so today I'm going to be talking about the basics of intellectual property, and I hope you're able to take away what is intellectual property, kind of the core foundations and fundamentals of it, and being able to distinguish and know the difference between each area of IP and know what will best suit your business needs. So when you hear intellectual property, what do you think? Intellectual property is a category of intangible property, and it refers to the creation of the mind, such as inventions, designs, and symbols. So intellectual property law protects those creations of the mind. And when you get intellectual property rights, the creator is awarded usually exclusive rights over these creations. And there are 4 different types of intellectual property, and each protects a different type of creation. You have copyrights, patents, trademarks, and trade secrets. Copyrights protect original works of authorship, patents protect inventions, trademarks protect your brand, and trade secrets protect confidential business information. So depending on what you're doing, you may need one source of protection or a combination of them. They all protect different parts of your business and afford you protection for different aspects. So I want to start off by discussing copyrights and where they originate from. The Constitution gives Congress the enumerated power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so copyrights are, they protect original works of authorship that are fixed in a tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated directly or with the aid of a machine and or a device. And so copyrights can actually be published or unpublished works. The main component and the spirit of the law is the original aspect of the work, and also it being in a fixed, tangible medium of expression. And so works of authorship, there's many different examples of what they can be and what that looks like. You have things such as books, literary works, musicals, sound recordings, photographs, website content, dramatic, paintings, company brochures. These are all great examples broadly of what copyright law can cover and what falls under copyrightable work. And some more real world examples of what that can be are things like the Harry Potter series, The Lion King, your favorite song, for instance. If you go to the Met or any other of those big galleries, any of those pieces you see there are copyrighted works. And all of those, again, are in that fixed, tangible medium that you can see and perceive. So authorship can get a little bit tricky and nuanced in terms of who is the author. And one example of where you see a little bit more complexity in that is in the workplace. So in the workplace, you have 2 different types of workers, right? You have an employee and an independent contractor. And when you're an employee author, your employer will own the copyright to whatever you create if what you're creating is in line and in scope of your employment. So meaning whatever you're hired to do, your ordinary tasks, if that's what you're performing, you will not own that copyright, despite the fact that you are the original creator of the work. Whereas An independent contractor author, unless otherwise stated in writing, independent contractors will own the rights to the work. So when you're working with independent contractors, which we do see a lot in some industries, such as when you're creative or in a startup, you want to make sure when you're making those agreements and outlining the scope of work and the terms of employment, you are speaking to intellectual property and putting clauses in there if you want to retain rights to works created during that time, just to make sure you do own that work in the end. So there are certain things that cannot be protected under copyright law, and those are ideas, procedures, processes, systems, methods of operation, concepts, principles, and discoveries. When you think back to our definition of copyrights, that fixed in a tangible medium of expression is very applicable here, because all of these things like ideas, methods of operations, and concepts, they can't be fixed or expressed in a tangible medium. So that kind of shows you why these things specifically cannot be protected under copyright law. So with copyrights, you are granted certain rights when you do have the copyright, and those are exclusive rights to reproduce, prepare derivative works, distribute copies, publicly perform, and publicly display your work. And you are allowed to license out those rights to others as you may please, and they can do that too if you give them the permission to. And with copyright registration, it's completely voluntary. Your copyright protection is created the moment the work is created. So when you think about, let's say you took a picture on your camera, the moment you've captured that moment, the picture, your copyright now exists and it's created. And registration is only required to pursue certain legal remedies. So although registration isn't necessary, it is very advantageous. And you're kind of looking forward and thinking ahead in the event that, let's say you need to do an infringement suit, you're going to have your copyright registered. So when you do that, after you've created it, you're protecting yourself in the long run, and kind of like a just in case, although you might not always need to invoke legal action, it's good to be able to if you need to. So copyrights do not last infinitely. They last the author's lifespan plus 70 years after that. And under copyright law, there is an area called fair use that I'm sure most of us are familiar with, especially if you watch YouTube. You might see a lot of those videos where they have that fair use disclaimer in front, where they're pulling from a whole different bunch of areas of copyrighted work. And so with fair use laws, you're allowed to use copyrighted work for the purpose of things such as criticism, comments, news reporting, teaching, scholarship, or research. And when you fall within those lines and under fair use, your use of that copyrighted work will not be considered infringement. Whereas, for example, maybe if someone goes to a movie theater and they're going to go watch the new Marvel movie and they record it on their phone and post it on a putlocker or something, that would be considered infringement and not fair use, because you're reproducing and using one of those exclusive rights that were not licensed out to you. Whereas compared to that, a Netflix, when you see all those movies there, whoever owns the copyright is giving them permission to reproduce and circulate around for people to watch their movies or whatever the content is, like music and Spotify, for example. Next up, I want to get into patents. Patents can be a little bit more tricky to understand out of all the areas of intellectual property. It's a bit more nuanced and more rules are involved. But let's just start out with the purpose of patents, which is to stimulate invention, and rights are protected to ensure creation and productivity in society, and also to share knowledge. Disclosing inventions is used to promote progress and general welfare. So some of the goals with patent law in the US system today is to solve a problem, make improvements, and increase efficiency. Today, when we see patents being issued and applied for, a lot of the times there's a need in a certain industry and someone has invented something that alleviates that issue and makes someone's life easier. A perfect example of that would be when Bluetooth was invented. Now we can all be in the car and our phone is wirelessly connected, playing our music, and then you can charge it at the same time. Whereas maybe back in the day with the older iPhones, and we had to use an aux cord, you would have to sacrifice charging your phone or listening to music. So an invention like Bluetooth really has changed and revolutionized society. You can see there was a problem there, many different types of problem. I know for me, choosing between listening to music or charging my phone was always an issue, especially in high school. And my phone would die. My mom would be like, "Why did your phone die?" Well, I had to listen to music. And then you see some improvements there. So the quality and of life has improved. You can now do multiple things and get the most use out of your phone. And efficiency has increased too, because now you're listening to music and you're charging your phone, and your phone doesn't have to die. And so what are patents? A patent grants the right to exclude others from making, using, or offering to sell the patented invention during the patented term. Like with most legal things, there's words that always have to be further defined. So we're going to go through and break down a lot of those words in there just so you can really understand what a patent is and what it encompasses. And so for gaining rights in the US, the system we follow is a first to file, meaning the first true inventor to file will be awarded the patent rights. And there are two different applications you can file, which are a provisional patent application and a non-provisional patent application. With a provisional patent application, you're allowed to file without any formal patent claim or any information disclosure. And the benefits of a provisional patent application is they do not get reviewed, but it is a way to establish a US filing date for the invention that can later be claimed in a non-provisional application. So going back to how the US system is structured, that can be very advantageous if you're not quite ready to fully disclose, but you want to make sure you have that date so you are the first person to file and you can have those rights. And a non-provisional patent is just a regular patent application that you go ahead and file when you're ready, and it includes all the components. So let's go into what can be an invention under patent law. So any machine, manufacture, process, or composition of matter can be patented. And those inventions must have these characteristics, which are novelty, non-obviousness, and utility. So let's just start off with novelty. Novelty is the invention is not previously known. Non-obviousness is the idea is new, and utility is the invention must function as needed, as intended. And so what can't be patented are a physical phenomenon, abstract ideas, laws of nature, and theoretical plans. And in terms of the patent term, for currently issued patents, they last 20 years from that filing date. So whether you do a non-provisional patent or provisional patent, whatever filing date is assigned to your patent, 20 years from then, your patent will expire. There are 3 different types of patents that you can gain. And the first is a utility patent. The next one is a design patent. And the last one is a plant patent. So a utility patent is granted to anyone who invents or discovers any new or useful process, machine, article of manufacture, or any new or useful improvement to the aforementioned. And a design patent is granted to any inventor who invents a new, original, and ornamental design for an article of manufacture. And an ornamental design is the appearance presented by the article, which creates an impression through the eye upon the observer. And lastly, a plant patent is granted for anyone who invents or discovers and asexually reproduces any distinct and new variety of plants. So with patents as compared to copyrights, you could see it's a little bit more defined in what it is and a little bit more rigid in terms of what can and can't be patented. But it covers a lot of different industries. Most people, when they hear patents, they think hard science, biology, chemists, people in a lab, but that's not the case. Many of our favorite brands do have patents, such as Nike, Apple. When you're innovating and you're really making a change and going out and inventing something, that can be patented. So don't think because maybe you're in the music field or a certain field that you can't have a patent. You just need to fall in line with what an invention can be, and that's not always scientific in nature. Next up, we're going to talk about one that I'm sure most of us know and are more familiar with and comfortable with, which is trademarks. And trademarks, the goals with trademarks are to provide legal protection for your brand, help guard against fraud and counterfeiting, and they really serve as an identifier for the source of goods and services in the marketplace. So before we jump into what exactly makes up a trademark, I just want to take a second to distinguish a trademark and a service mark. I'll probably mostly be saying trademark or mark just because it rolls off the tongue easier and to limit confusion. But a trademark is used to identify products and goods, whereas a service mark is used to identify a service, but they pretty much both do the same thing. The difference is what you're identifying and what you're doing. So if you have a product or good, trademark, a service, then it'll be a service mark. And so what are they? Trademarks and service marks are it's your brand identity, and it indicates the source of goods and services. Any word, phrase, symbol, or combination of these that identifies a good or service in the marketplace can be trademarked. And one of the most important aspects to reiterate is it will distinguish your good and services from others being sold in the marketplace. So it's a way to get your brand out there and show this is us. And the best way to think about it is when you think about the golden arches, when you think about McDonald's, when you think about the apple that's bitten into, you automatically think about Apple products, iPhones, and all of these things. You know your brand is tied to your trademark. So as your trademark gets more known, people are able to identify you in the marketplace without even seeing your name. If you just saw a pair of AirPods laying down, for example, you would immediately think Apple, and so on and so forth. So that's really what a trademark serves to do. So some examples of what can be protected under trademark law are slogans, color schemes, smells, sounds, and words. So an example of a sound that's been trademarked is the NBC chimes. If you watch NBC shows, you usually hear it before the show comes on. Or a color scheme, Tiffany blue is a very popular color scheme that is trademarked, and a lot of different other luxury brands do have certain colorways that they use trademarked for them. And the term of ownership for trademarks, they last so long as there's continued use and exercise control over the quality of goods and services. So unlike copyrights and patents, trademarks last so long as you want them to. It is totally in your control whether your trademark lasts or it's abandoned. So when you become an owner for a trademark protection is created as soon as you start using your mark with your goods and services in commerce. So just like copyrights, registration is not required unless you're seeking certain legal remedies, but it is advantageous. For example, if you want to sue someone for an infringement, you're going to have your trademark registered to be able to pursue that. Common law will only take you so far. And also with trademarks, you do see a lot of infringement, especially on social media, in the marketplace, and people making clothes. A lot of people are stealing. And although you think you might be too small, you're never too small for IP protection because there's always somebody watching, whether you know it or not. And like if you look at IG analytic tools, for example, you might only get 2 likes on your posts, but your analytics are through the roof. And those are people watching you and seeing your products. So you want to make sure it's protected. A lot of people think I just need to be bigger or wait until my company has grown before I seek protection. But the moment you have an idea, protection is advantageous. That way, when there comes a time, you don't want to be backtracking or having your attorney trying to fight something that could have been prevented from the beginning. And with trademark law, first use in commerce will have superior registration rights. So although your trademark is created at the use, when you want to go ahead and register, you might find out that someone was using that mark way before you, years before you, and now you have this brand that your customers trust and people are loyal to, and you have to totally rebrand. And rebranding is not always easy and doesn't work for everyone. So you want to make sure not only that you're using it, you get it registered, and you're even able to get it registered just to make sure there's not someone else out there who has superior rights over you, and you might have to switch up everything you've been doing, which can be costly and you might lose customers. So there are different types of trademarks, some stronger than others and some more likely to get registration versus the others. So the types we have are generic, descriptive, suggestive, arbitrary, coined, or fanciful. So let's start off with generic. These are common names not capable of exclusive ownership. For example, pizza, home, car, and shoe. None of those can be trademarked. And quite frankly, it would be really crazy if we could trademark regular words, because imagine one day you order pizza for your family and someone's hitting you with a cease and desist because you talked about it on Twitter. Society just would not be able to function. And so next up, we have descriptive marks, which describe a feature of the good, and these are not protectable until they acquire a secondary meaning in the consumer's minds. It must become associated with the product that it identifies and distinguishes it from others. And so next up, onto the more stronger marks, we have a suggestive mark, which suggests something about the product but does not describe it. These marks require imagination, thought, and perception. And a perfect example of that is Eskimo pie. If you're a snack eater, it is, I believe, a cookie type of snack. I am not a snack eater, but I'm pretty sure it's a cookie type of snack. And obviously, when you hear Eskimo pie, you would not expect food. So that's a perfect example of a suggestive mark. And next up, we have fanciful marks, which are totally made up words. So a perfect example, and probably one of the most popular, is Kodak. I actually did not know Kodak was not a real word until I took trademark law, but that is a perfect example of a fanciful mark. And lastly, we have arbitrary, which are marks that use well-known words with a different meaning. So you can kind of contrast that with generic. And a perfect example would be Apple, the brand. I'm team iPhone, so sorry for all the Apple references, but that is a perfect example of an arbitrary mark. So next up and last, we have trade secrets. And this area of intellectual property is, I would say, not as known and not commonly known among the layperson. So, but it's very good to have knowledge of it and to know when you might have one and how to protect it. So a trade secret is confidential business information that is generally not known to others in the trade or business that gives a company an economic advantage over its competitors. So some example of trade secrets that are pretty popular, if you've been to the Coca-Cola Museum in Atlanta, there's like a vault there and they have the Coca-Cola formula. So that's a perfect example of a trade secret. And trade secrets can be formulas, supplier lists, manufacturing processes, vendors, computer programs, customer lists, business methods, and even negative information. So negative information is definitely an interesting one. And an example of that would be if you know how to not do something, that can be a trade secret, because if it's not known in the industry that that is not the correct way to do it, you yourself and your company have a trade secret there, which is pretty interesting because usually when you think of intellectual property, you're probably thinking in the positive and what's going to benefit. But with trade secrets, the neat thing about that is things that are not beneficial are protectable too. So unlike patents, trademarks, and copyrights, where we saw a pattern of registration is advantageous and or required like it is for patents, protecting a trade secret requires maintaining secrecy rather than an official filing process for protection. And trade secret laws will protect you against misappropriation, theft, and purposeful and or careless revelations of that trade secret. So I want to leave you with some ways to maintain secrecy, and those can be through diligent policies, protecting your trade secret through contractual obligations such as NDAs or speaking to it in an employment contract, identifying your trade secret. Part of protecting it is knowing it exists. And so you want to make sure you are very cognizant of what it is and what benefit it has to you, and also restricting access to the trade secret, especially as your company grows. Everyone doesn't need to know everything. And part of restricting access will definitely help you maintain that secrecy that is required. And so some of the ways you can do that are having visitor logs, so you know what's happening, who's there, and you can kind of be able to trace back if there is a leak, having secure spaces, need to know, cleansing your old hard drives, and also NDAs again. So trade secrets, it's not as popular, I would say, as the other areas in pop culture, but it is still beneficial and can definitely serve your business, especially if you're in a business where secrecy and is used, and having competitive edges and being able to do something better will help your business. And so those are all the areas of intellectual property. I hope now you're able to distinguish between a patent, a trademark, a copyright, and a trade secret, and just to equip yourself with the knowledge to look at your business from the inside and know, okay, I need this type of protection, or we're going into this venture and this is the type of protection I need to seek. I think a lot of us as creatives and business owners, we tend to put the legal on the back burner, but part of growing your business is being legally sound. And it also can help with profit and revenue, because if you're spending so much time fighting, you're not spending time growing your business. So I thank you all for joining me, and I hope you take away some information.
Thank you so much, Ego. I definitely appreciate, those pieces of IP that you were able to convey. Companies definitely need to pursue that IP protection early, so they can last longer in the business development process. It helps them with funding. It helps them to protect themselves from others. There's a wide variety of things that can help, by getting the IP early. And I want to transition to speak a little bit about IPGen. But before I do that, I always want to commend, our team for how, for the work that they're doing now. Star and Ego. We also have Jason, Tiana, Anthony, and someone new coming on now, Sydney. I'm just saying first names now, but I definitely appreciate, every piece that everyone's putting in to make IPGen the company that it is now and where we're going in the future. I'm excited about it. We're doing some great things over here. And just a bit about it, we're building a platform, an innovation platform, where we have an underlying IP agenda. So we're building tools to automate and streamline aspects of each one of the IP processes. We started with the patent side, and we'll be building trademark and copyrights next. But now we're starting to bring on users and things of that nature, and people are really excited about being able to pursue that IP early. Even people and companies who didn't know, much about IP already, they're hopping onto the platform. They're using it, ease of use, and all of that. So we want to invite, everyone watching this webinar. If you have any IP needs, whether it be patents, trademarks, copyrights, if you have any information for trade secrets as well, definitely check us out at IPGen.io. You can even send us send a direct email at info@IPGen.io to get you started and get you some more information. As we continue to grow, we're going to expand to include freelancers and investors on our platform as well, to assist these startups. And the startups and entrepreneurs are, our first target audience. But we're also building features for attorneys and law firms to be able to streamline their processes and work with their clients on our platform. So your big law firms can work with the big clients together on one platform to further their IP goals. It's an exciting time for us as we begin to grow. If you have any questions, definitely feel free to reach out to us on LinkedIn, email, website. We're here for you. Thank you again for viewing this webinar in conjunction with TEDCO. One last thing, if you need anything business related wise, definitely seek TEDCO, go to their website as well. They have a plethora of knowledge there for you. So I'll leave you there. Thank you again from IPGen.